skills and expertise one requires of investigators, so be they DPCI or IDEC. We need investigative experience, and you need knowledge and understanding of the law enforcement environment. So that is what he had when he did come to IDEC back at the time, and they did serve us well in terms of investigations. And if you'd allow me, Honorable Sangoni, just for clarity, he didn't conduct the investigations in any of these matters by himself. There's a team of investigators and prosecutors, and everybody does different things. Different people take statements, some issue Section 28 subpoenas, etc. In terms of the conducting of the investigation, there is a team that conducts an investigation and more than one prosecutor that assesses the matter. However, when we effect arrests, and this is a general law enforcement thing, you will find that when an arrest is to be effected, search and seizure warrants are to be applied for, cyber warrants, bail affidavits. They choose within the team who must depose to that affidavit. And for those reasons, he is at the fore, but he is part of a team. I only just wanted to clarify. I'm not trying to justify anything.
No, I think I understand you, but I'm sure you'll appreciate also, Advocate Johnson, that our line of questioning is based on the allegations that have been put before us, which intimate that he was intimately involved. He was also involved in the arrest, wasn't he?
He was not at the arrest.
He was not at the arrest. Okay, only the investigation. So I was asking you, these skills that he possesses, are they only possessed by a person who has retired? Because I would think that if they were the requirements of the job, we're not creating job for retirees, am I right?
Honorable Sangoni, when I took office at IDEC, the issue was we had duty reassigned or seconded individuals. Many of them were already at an advanced age. When we started recruiting as well, the experienced investigators in criminal matters are of an advanced age. And that is the same answer you would get even if you talk to the DPCI and you talk to the detectives. And of an advanced age doesn't of necessity mean that they reach their retirement age. Many of these experienced law enforcement officers also left for different reasons before the time. But many of them are the more senior people, without casting aspersions on anybody's age. But the experience came from there.
But he had retired and was brought back or headhunted.
In terms of what I have from his statement and what we have from my finding him there, it is correct. He had come out of retirement.
Okay, so I suppose then the assertion that I'm putting to you, Advocate Johnson, is that you have this person who is employed in one entity in the criminal justice system, purportedly is retired, thereafter he's brought back, he comes into this other criminal justice system ecosystem, proceeds to investigate as part of a team, charge, arrest his former colleagues who include the senior officials and people that he reported to. At no point did anybody think that this was conflict of some sort, there was something strange here, no?
I can do no more than indicate the team scenario, and each one of them delegate the duties. He did not arrest Lieutenant General Khumalo, but he was involved in the processing of the co-accused who had handed themselves over to the South African Police Services. So he was part of a team. When you think about it, the optics don't look good, but there was nothing untoward.
Okay, Advocate Johnson, there's lots of optics that look funny here. So General Khumalo, General Mkhwanazi asserts is being targeted, right? So in December, they raid Mr. Nhlanhla's house. There's then a fabricated case that they stole Rolex watches. Also in December, it is alleged that Mr. Brown Mkhwanazi sends an SMS to the minister that says, yeah, now we've got something, we can finally charge Khumalo. Then in June, you arrest him. Sorry. So IDEC arrests him. Does this not look like a coordinated campaign against General Khumalo?
It doesn't, simply because you have to look at who is dealing with what. We were not dealing with, nor were we involved in whatever happened in December, be it for Nhlanhla or for Mkhwanazi, bearing in mind, Honorable Sangoni, that at the time we didn't even have the referral for the Nhlanhla tender corruption matter. Ours dealt only with what came from Adams. If there was a concerted effort, then the timing of everything would have happened differently, logically, would have happened differently, and then we wouldn't have gone on what everyone goes on about is, what were you doing with what they allege is an HR or labor issue? We would have taken all those other allegations that are purported to have been made and hit him with a full book of allegations. That's not what we did. That wasn't our case. Our case was different, and we were not working hand in glove with anybody outside of IDEC.
Okay. But you can see coincidence, right?
Stinks of coincidence.
Okay, okay. So just help me. Why, having now heard all of these allegations, are you not investigating them? Because when you spoke about your mandate, you said you are only limited by the extent of the mandate. You don't only investigate 90% of a thing, you go all the way. Now, why are you not investigating organized crime and drug cartels? Because your mandate says that you can deal with issues. In fact, I want to read it if I can find it. It's 9.2 somewhere. But in your mandate, you say that issues that relate to the Contravention of Prevention of Organized Crime Act, they fall within your mandate. So why are you not broadening the scope since your mandate allows you?
That part of the mandate, Honorable Sangoni, relates to matters of racketeering and matters of money laundering. That is where IDEC gets its mandate. Because in the corruption matters and or the financial crimes matters, there would be money laundering, as has been evident through the State Capture Commission, etc. Those, for us to prefer those charges and conduct those investigations, they fall within very specific provisions of the Prevention of Organized Crime Act. That is the purpose of having all of those parts of the legislation referred to. We did not want to run the risk that you do not mention a statute that we are allowed to deal with. That is what we do, and that's where we have restricted ourselves. But if there's organized corruption and it is reported, and if that corruption relates to organized crime, we can investigate it, but we don't investigate organized crime. I hope that clarifies.
Okay, now I hear you. So in your statement, and I'm going to tread carefully here because the chair did say he doesn't want us to discuss allegations, but I want to discuss the justification that you have given us. And I think some of the members have already touched on this. But you quote Justice Zondo that state capture is a project where a group of actors, their network of collaborators, systemically conspire to redirect state resources for their own private gain. Then in paragraph 3.1, paragraph 38, you then list the elements of what make up state capture. In 1, you indicate that state capture can manifest where there is a conspiracy to redirect resources to correct purposes. So now, how was this accused number 7, Mrs. Mokwele, going to do this? How was she going to redirect resources for corrupt processes?
Just for clarity, Honorable Sangoni, I took that entire definition and all of the elements. Not every one of those elements are applicable to all of the accused.
You will indicate. So if
terms of
she was not going to, I'll go through them. So she doesn't fall within the conspiracy to redirect resources for corrupt purposes.
The allegation that we make is she was put in a strategic position so that when she was requested to, she would redirect resources or funding for the resources because of the nature of TSS, their funding and what it is they can procure.
Okay, I want to be clear, and again, very careful. Are you speculating that she will be in a position to do that, or you would then have, I don't need to know the evidence, you then have evidence that that is what they were plotting to do?
We have evidence that that is what they were plotting to do, and I did say it is unfortunate that I'm unable to discuss the other matters, not just these 2 matters. But when you look at the full ambit or basket of matters, Honorable Member, then they do give you a different picture.
Okay. Then on the next one, which is the strategic appointments and dismissal, right? So Judge Zondo says this entails the filling of posts with loyalists who would then facilitate capture. So is it your evidence, and I don't want to know your evidence, that Ms. Mukwele was going to facilitate capture of crime intelligence? The co-accused. Okay. And then the manipulation of procurement is what you were talking about? Okay. I think Honorable Mngango has already asked you about the systems and processes and private interests and so forth. So if these are all the issues, then, Advocate, why would you then go and charge him on employment-related issues when you have evidence that there is a conspiracy to capture crime intelligence? Why don't you go for the jugular instead of confusing all of us with employment matters?
In terms of this particular appointment, it is its own standalone matter. When we have the other four matters, we have to look at whether...
Mike, please, sorry, ma'am.
When you look at this matter, I must be tired if I keep forgetting the mic. I do apologize, Honorable Chair. This was a matter that stood alone. I did indicate that we had to first look at which matters can be prosecuted on their own. When we look at the balance of the matters, we have to look at whether or not some, if not all of these accused and other persons, did not act as a criminal enterprise to conspire and further the ends to which we allude. And that is part of the prosecution and investigation strategy.
Okay.
Not every matter would fall there, but the remaining matters are exactly what we have to consider.
Okay. So you've also said somewhere that there are persons who have been appointed that allowed the head of criminal intelligence to access funds without proper processes. So who are these people? How come they are not charged? Like, what happened to that? I mean, it's a big statement for Madam IDEC to make, and people are roaming around free.
So we also have, that would be the seventh matter, which is a Nhlanhla matter, which refers to procurement, which is also under investigation. It hasn't fallen under the radar, Honorable Member.
Okay. I was going to ask you, but I think I'll ask it anyway for the sake of completeness. Is this matter of Lieutenant General Khumalo the only matter that you have dealt with which relates to manipulation of employment? Is there precedence for this? Because, yeah, is there precedence for this? Has this ever been done?
In IDEC, this was the first one that we had done. I can't answer for if it was done in the rest of the NPA. It's something I would have to find out, or else I would be misrepresenting facts, which I cannot.
Okay. On paragraph 29 of your testimony, you indicated that, so you speak glowingly about crime intelligence, then that you indicate that the key challenge in relation to crime intelligence is the use of funds and the lack of accountability thereof. Drawing from your experience, and I think I want to step off these contemporary issues now, but drawing from your experience, what recommendations would you have to tighten the Secret Service account, the slush fund? I mean, we asked the minister, he said, yeah, I don't know. What recommendations would you have? You've been through the Celebi matter, the Lazarus matter, what you call the Lazarus Mdluli era. What needs to be done there?
Honorable Sangoni, I did indicate earlier that what one should do is allow greater latitude to the Inspector General for them to be able to openly look at the books and to be able to account cent for cent and legitimacy, whether it is of procurement of goods and or services. But the same should be allowed of the Auditor General. And I am saying we do have bodies that can do it. We have to find a mechanism, given the covert secret nature of this account, to allow them to do that. It might then mean that the Joint Standing Committee on Intelligence is going to have to sit down, have a debate, and perhaps seriously consider an amendment to the legislation. There is a protection, and they then have to ask the question, what is this protection doing for the fight against crime and for accountability and transparency. I think that might work.
Okay, I'm almost done. One of our terms of references speaks to us investigating prosecutorial conduct between IDEC and the KPTT, Political Killings Task Team. I just want to make sure that I heard you right. IDEC has no relationship with the PKTT whatsoever. We can scratch that off our terms of reference.
Absolutely. I can say that with both my hands raised to God. There's nothing we have to do with PKTT.
Okay. And then what is the conviction rate of IDEC or ID, then IDEC?
Sorry, we had in this year, we've had 1, 2, 3 so far. The unfortunate thing about these matters is they take such a long time. They even frustrate us that they take so long. But it's usually lots of accused, lots of lawyers. And I know what the South African public wants, and they're absolutely entitled, Honorable Sangoni, to want speedy justice. But unfortunately, these are voluminous matters, and they just simply take forever. What we have done is we have engaged with the National Director, and I am aware that there are engagements that, if they haven't already happened, will happen with the Honorable Chief Justice to ask for a fast, I'll just use the terminology we used, for a fast lane court. We're not asking to create special courts, but to say when we have a state capture matter that must go on trial, the JP of that division must know this is state capture. They must get a judge who will then sit in a dedicated court to run with the matter start to finish. The chances of you finishing some of these matters within 6 months to a year, as opposed to the 5 to 10 years that it's taking us because we are given space on existing court rules, specialized commercial crime, as well as the regional court, and we also, Honorable Sangoni, have to fall into the high court role. It is not ideal, and it is impractical, but I am aware that there are considerations for what they call a fast-track court, experienced, dedicated judges to run start to finish.
Okay, yeah, I was going to ask you what needs to be done to fast track it, but then even if you've got a fast track court, you get in there and the public believes, well, I believe, that you get there and then your things are thrown out. Like, what are you going to do about that? Because that also seems to be a problem.
Well, for us, first prize is finding a court that will only deal with IDEC's state capture matter that is brought before it. But at the stage it gets to that court, it must be trial ready. So all of the other processes and whatever motion applications are brought must be dealt with by court of first instance, so that when we go to the Chief Justice or to the JP, we are saying all the parties, including the defense, we are ready. We want the judge to start our trial, and that is what we have to aim to do.
Advocate Johnson, I know maybe I'm unfairly targeting you because it's the NPA generally, but can you understand how frustrated people are that you would bring cases, and I'm sure it's both sides, you know, both the accused and members of the public, you bring cases, nothing sticks, you have to go back, and it looks like the NPA/IDEC is just fumbling cases and people are losing confidence in the system.
Honorable Sangoni, I take what you say. In terms of the IDEC matters, I know that we did have an unfortunate incident in terms of the New Lane matter, and without discussing the trial judge, I think the Supreme Court of Appeal judgment speaks volumes on what went wrong. It has cost us a lot of time. It's cost us over 2 years to get that judgment. Now the same accused, when we were ready to enroll the matter, have taken us to the Constitutional Court. Accused persons have rights, and so they do exhaust them as they do. But are you asking if the NPA can do better? Of course, that is what we were supposed to do. We must aim to do better.
Are you working on doing better? What is being done to improve the output? Well, yeah, I'll call it output of the NPA.
So if you look at the IDEC matters, I've indicated what we seek to do, and we seek that when we enroll a matter, that at the date of enrollment, all the investigations are done and we are ready to make disclosure of the docket, which then becomes very important and determines then the speed at which that matter becomes enrolled. And that has become a general principle with the commercial and corruption matters that are also dealt with by my colleagues in the DPP offices and specialized commercial crime.
Okay, I'm gonna step off this, but I do have to just throw in this one thing. Do you think that, I mean, you spoke about the implications, right, of things that, let's say, General Mkhwanazi does. Do you think that the NPA should take any accountability when they do bring matters to court, the matters are not ready, and people lose their livelihoods because the NPA bungled things, took them to court, they were not ready, people lose their jobs and all sorts of things? Or is the way that it is now okay? It's like, oh no, we'll do better.
No, it cannot be business as usual. And what you say is exactly how it should be. And that is why I was at pains to say, you know, when you just even mention who might be a suspect, the irreparable harm you do, no one cares that you didn't end up charging Mr. or Mrs. X. They remember what you said. And that is the same for matters going to court, matters then being withdrawn, and those matters then falling by the wayside.
Okay. I think it's even worse when you're charged, you know, and not just mentioned, but I get your point. Honorable Johnson, has in your experience, both as, okay, I won't go to the Scorpions, but as a prosecutor, let's say in the last couple of years, has there been political interference in your work, let's say especially the ID and IDEC, and could you give us the details of that political interference?
So we won't talk about the DSO because I think that is history written. But since then, I myself, in my work environment, have not had political interference. Of course, we had members of the NPA where there's allegations that they had been captured, and many of us, myself included, were victimized, where we were not allowed to deal with our matters at all. And we were moved office to office. I mean, I was physically moved in one building 4 times at the women fancy of one of the national directors. At a stage, I ended up working out of my boxes because that was the best thing for me to do. In my time in IDEC, not then Minister Ronald Lamola, not Minister Simelane, and not the current Minister, Mayor Mamoloko Kubai, have sought to interfere in the work. They have not asked me, as IDEC, to provide them with details of the merits of matters. They have not asked that they be informed when persons will be arrested, because that is where you would look at for interference. However, all ministers are entitled to ask for a high-level report in terms of Section 33 of the NPA Act. I think there was only one instance where a report was provided to the Honorable Minister Lamola at the time. There was nothing untoward about it. It was more clarity, but none of the ministers since then either have asked, which they can legitimately ask for.
So the lack of prosecution is not because you have politicians, ministers interfering in your work and saying, do not prosecute this one, frustrating you, things of that nature?
Our challenges are different. They are not political interference.
Thank you very much. I think my second last question, if not the last question, okay, I've forgotten this. Let me go to the last question. I was worried about your response, Advocate Johnson, when you were asked about the duplication of functions. I think it was, I'm not sure if it was Honorable Cameron or Honorable Klopper who was proposing a protocol. Now, when Minister Kachalia was here, he went to great lengths speaking about this duplication, scope creep, and whatnot, right? Now, your response suggests to me that you think that the criminal justice system should be run on collegiality. We must just speak together more. We must just do this and this. And I'd really want you to think about this duplication. Minister Kachalia proposes, for example, the establishment of an OPI, I think Office of Integrity, Public Integrity or something, which would then look at IDEC, which would look at the Hawks, the SIU. Don't you think a mechanism like that could strengthen the fight against corruption, in particular, crime in general?
So my response in terms of as it stands And because there isn't a coordinating mechanism, that collegiality was the only way we were able to get over those hurdles. I have seen the NACAC recommendations, and they make sense, so much so that there isn't a straddling of mandates. So the DPCI, as per those NACAC recommendations, ought only, if they are accepted and go through Parliament, only deal with organized crime. And that matters of corruption, serious economic offenses should fall within the mandate of IDEC. And in terms of the OPI, it is almost an absorption of the SIU, but with a bit more functions than which they currently have. I think that would talk to a bringing of all the law enforcement, aligning the mandates, keeping mandates restricted and effective, with the detective still having to do the lower level crimes. And what they also then put in there, which is what we don't have, is a coordinating body that will look at the cases that are coming in, who's doing what, and how we can perhaps help with the resources, etc. So for the first time, there'd be a all-round coordinating mechanism. And I think if we give it a try, the chances of it doing us greater good would be.
Okay, thank you. Chair, I'm done, but I just want to ask Advocate Johnson before I step off. Advocate, we don't want another 6th of July media briefing. So I want to ask you here, right, that where you are sitting, and I'm sensitive obviously to the last part of your statement in terms of threats. Are you sitting in a position where your life is being made difficult? I mean, in terms of the work of IDEC, that you can't function, you have all these syndicates, influences, interferences that make it difficult for you to do your work. Because I won't come back after you answer that question, could I also request, if possible, in writing, any recommendations you would want the committee to consider to strengthen IDEC or even the criminal justice system in totality? Are you going to do a 6th of July on us anytime soon?
I didn't do a 6th of July, but a 6th of July was unnecessary. However, I do not know what attempts Lieutenant General Mkhwanazi made to escalate, got no joy, as he says. And when people are frustrated and their intentions are good, sometimes it comes out in the manner that it came out. But in terms of the death threats aside, I am able to do my work. It's a lot on one's shoulders. You cannot forget it. You can't just, I don't relax. There's no relaxing and just getting to work. So one would have liked me to be the me.
The time of the members expired.
Thank you, Advocate Johnson, and I'm happy that you're not frustrated. Thank you so much for sharing your time with us. Thank you.
Thank you.
Honorable members, can I check those who want to make follow-ups? Honorable Matthews, Honorable Sols will be the two speakers. The list is closed.
Thank you, Chair. To follow up on the issue of political interference, I just want you to speak a little bit too. So you said you haven't had any political leaders, ministers, etc., come directly to you. Politicians, by nature, if they are not clumsy, they're not going to come to someone that they haven't captured yet. And do you think that the issues that you are having, because you said you do, or you have worked under, and you still do, under very trying situations, they have to be fueled somewhere, because it's no way that just bureaucrats can do that without being protected or being fueled by politicians in the background. That's my statement. I would like you to speak to that. And I'm not saying that you must identify any politicians, but that is a fact. There's no way bureaucrats can get away with half of the things they do if they are not in the pockets of politicians or being directed by politicians.
You put it so eloquently, Honorable Matthews. I'm not sure what response I'm able to give. Safe to say, I have had concerns ever since the death threat and the 6th of July media briefing. And I'll tell you why. what you see is what you get. I don't know how to be different, Andrea Johnson or the ID. And so when people were in the public space connecting dots that I didn't even see, I had to ask myself the question, who are you and why? And is it necessarily the person who took to a podium? I still don't have the answers. I do have a suspicion that something bigger is aimed at targeting, if not IDEC, the ID. But that is where I put it on pause. Unfortunately, I do believe
No, I
the
understand.
Lord will show them up. It may sound philosophical, but that is all I can wish for. But I do hope I find the sources in IDEC, because that would also give an indication of what the agenda is and who's running it.
One day is one day. And can we safely say that state capture has continued under Cyril Ramaphosa, President Cyril Ramaphosa? Because these cases we're talking about are post-Zondo Commission.
I cannot say that state capture happened under a specific person, because that person is not implicated in any of the cases IDEC currently deals with, except that capture continues. It even happened after the Zondo Commission with the PPE procurement. Corruption is rife. That you cannot take away. I can't attribute it to any one specific person other than the people whom allegations are made against and whom IDEC would have to investigate.
Now, I wasn't saying the person, administration, so the Cyril Ramaphosa administration, but you've answered our question. Thank you, Admin.
Thank you.
Yeah, just to remind members, President Cyril Ramaphosa, we elected him here in June last year, and by an overwhelming majority. My friend, Honorable Sols.
No, Chair, I can't be your friend. You are my elder. You are my senior. Too much respect for you to be called your friend. Honorable Chair, Honorable Advocate, we just got information on recruitment. The follow-up is on the recruitment. Just got information that there was a post of senior criminal investigator that was advertised 2024, and the appointment was made this year, 2025. A colored female, LLB degree, many years of experience, applied, and those who got appointed has less experience than her. And then she was victimized when she wrote a grievance or lodged a grievance against these unfair appointments. So I want to put it to you, we can prove, and we want to debunk the notion that coloreds do not apply and they do not qualify. Earlier, I didn't have this information. I received it now. And I put it to you that IDEC must do more, because coloreds, there are coloreds out there that qualifies and that can contribute to the well-being of this country.
I take note. There was a labor dispute that was declared. I'm therefore not going to discuss the matter. Safe to say it is a one-sided story that the Honorable Sols has been given, and it is unfortunate. But I do know what you are talking about, but the person had declared a grievance against myself and various officials in IDEC. I'm therefore unable to discuss that matter, but I do know what you're talking about, Honorable Sols.
Can I just say that I obviously don't know the details, and that's not important for me. What is important for me is you can confirm she's colored, she has qualifications, and there are colors that applies. I just want to debunk the notion that colors don't apply and they are not there qualified. That's the issue here. Let's do more to be inclusive. because there are colors that are professional and do qualify. That's the point.
I'll take your point.
Honorable Nomvalo, your time starts now.
Thank you, Chair. I don't think I will be long, Chair. Good evening.
Okay,
good
just
evening,
hold a moment. We get Honorable Malem.
I don't know, Chair, but I think it's unfair on the witness to use one incident to create a phenomenon that is non-existent. Because it's very unfair on her to say, because of one incident, colors are applying and they are not being appointed on the suitable cases. So from that point, I think we should protect her. She gave us her answer on the matter, and that's her answer. We can't use one isolated incident to want to prove a non-existing crisis.
No, Honorable Sole, wait, I don't want that. I don't want you to debate the matter. The reality which has been presented here and which has been acknowledged is that there is an underrepresentation of colored people in IDEC. And I think it's a matter which we should be worried about. And if there is a way, persuade the leadership of IDEC here to pay attention to it. They have been excluded for many years. And I think it's very important that we look at that. Honorable Souls might have lacked a better way to present it, Honorable Malem. But the truth that remains is that the colored population of South Africa also deserve recognition. It's very rare that you see them in any of the state departments, especially at the highest echelon of leadership. So the point, Honorable Sol, I think has been driven home, and we must take it as such. Honorable Nomval.
Thank you very much, Chair. Thank you very much, Chair. Good evening, Advocate.
Good evening, Honorable Namvalo.
Was the National Commissioner not involved and the moderating committee of SAPS in a recruitment process for which General Khumalo was arrested? Were they not involved as role players of any kind?
If you will just clarify, are you asking if they had any engagement with IDEC?
No, I'm saying for the HR processes for which General Khumalo was arrested, did they not play any role?
What I do know from what I have, I'm sure there's documentation in terms of the investigation to show who would have signed. I think their corporate services head of HR would have signed that final letter of appointment, but they would have accepted whatever the recommendation was. That's how I understand process. Whatever the recommendation was that came out of that specific panel, they would then have, short of them having questions, which I don't know whether they had, the appointment would then be endorsed and made. So administratively, that is the involvement I would see of anyone else outside of the panel. It happens across the board.
Yeah, because my subsequent question was going to be on the appointment letter. If you saw it and who signed it, if you saw it. Did you see the appointment letter?
The investigation team would have it. I didn't see who signed the appointment letter, but if I take how IDEC works, the head of human resources would sign the letter or send an offer of the appointment to the incumbent for them to accept. I don't think it would be different, Honorable Nomvalo, for the South African Police Services.
So if they are found to have played a role, maybe through effecting their signatures, then they are also going to be liable, correct?
In terms of what we are alleging as the criminality, we are talking about the initial recruitment process. So unless there was a reason for anyone, after the panel made a recommendation, to question whatever it is that and it also depends, sorry, Honorable Nhlanhla, on how the recommendation is written, what is put in the motivation. There may have not been any red flags that anyone else would have seen, because it depends on how a panel couched its recommendations and its motivation.
Okay, no, the reason why I'm asking is, you will correct me if you have a different understanding, is that if there were many role players, then they were supposed to be arrested in terms of the principle of doctrine of purpose. People who participated in the recruitment process, they were supposed to be arrested, all of them, because they acted in common purpose to execute what is illegal, or what you alleged to be illegal.
What I understand differently, Honorable Nhlanhla, is we are talking about the initial process. There couldn't have been any common purpose in the administration of the acceptance of the recommendation. And that is why I'm saying how it was written and the motivation. If there was nothing there to raise red flags, what criminal common purpose can the state allege against anyone outside of that initial group?
Okay. Now let's move to another question. You said General Khumalo was arrested as a consequence of a referral that was made by Honorable Adams, correct?
Correct.
And Honorable Adams made that referral in terms of Section 27, is that correct?
Correct.
Now, when was this referral authorized?
The referral was made on the 22nd of November. The investigation itself was authorized on the 6th of December.
So it was authorized on the 6th of December.
That is correct.
And
Because
then-
investigations wouldn't have been able to continue without
Yes.
the authorization, Honorable Member.
Okay. And then you further said for a referral to pass or to be successful, there must be an affidavit to which the deponent has deposed. Is that correct?
That is correct.
Now, in this referral that was made in November 2024, on the 21st, was there any affidavit attached on the referral that was made in November?
The referral is an affidavit made by Mr. Adams.
And that affidavit is dated?
The 22nd of November, 2024.
Do you have it in your possession?
No, I don't.
Don't you think it was going to be important for you? Because another problem which I have with your statement is that documents which are relevant have not been attached. Not only because to some of us, documents are helping us to cross-reference and to see if there is corroboration between your statements and the attachments that are relevant to your statement. Now, if we just rely on a statement, and there is a precedent that has been made by witnesses who have come before you, they make, for easy reference, they make huge bundles of attachments so that we can be able to go further in terms of making sure that we broaden our insight. Now, my problem here is that you have not attached the relevant documents. The second document which is relevant, which you have not attached, is a letter that you wrote to a general requesting for the dockets that you wrote in December. But let's go back to this referral. You know that a docket is a public document, right?
No.
Would you agree with me if I say to you, the affidavit of Honorable Adams is dated the 6th of January, 2025.
That would be a supplementary affidavit because follow-up engagements were had by the investigating team with Mr. Adams. I did indicate that as well earlier. So yes, there would be a 6 January document.
Can you be able to furnish us with the original affidavit?
Unfortunately, Honorable Chair and members, that is not a document that I can disclose. But if there are of the other documents, this document has not even been disclosed to the defense. And it is one of those documents where even the defense would have to apply for the document to be made available to them. The Section 27 referral cannot be made available, but other documents that Honorable Nhlanhla or any other member says should have been here, what I would ask all of the honorable members is to kindly provide the chair with a list, and those documents that can be made available should be made available to this House in the course of next week as part of a bundle, which would then be referenced according to the affidavit and then be sent to the evidence leader for distribution. But where we are with the current matter, and because the Section 27 also, Honorable Nhlanhla, still relates to other investigations that are pending, the Section 27 referral will not be made available. I'm not being difficult, I'm just indicating that in terms of where we are in the process, IDEC cannot make the Section 27 available.
So is it a classified document?
It's not a classified document as in we've written on it top secret. It is a document that seeks to initiate the intake of a matter. It is a document that, should it be disclosed, will have to first be disclosed to an accused. That document has not been made available to any of the accused. I can therefore not make any of those documents available. It is not like the charge sheet. It's not a public document.
So which...
It is a confidential document that deals with the intake of a matter within IDEC and how the matter is then considered for intake and then for the later authorization.
So which law are you relying on to make that proposition?
I'm saying that in terms of process, we have not disclosed a Section 27 referral. It is a confidential document similar to how we have memos in the NPA. And not just IDEC. There are certain documents that are not made available for public consideration.
Yeah, but which law? You mean, when you say in terms of the process,
So
you mean in terms of the established precedent within the organization, or there is a particular law that speaks to that effect?
So I cannot give you the law that deals with that. I talk to the confidentiality of the document and what it purports to do. So that document is used for a very specific purpose, and it is used to initiate an intake and a referral. It is a confidential internal document.
Yeah, no, if that is the case, then I think I am left helpless, but I will just put this proposition to you. The affidavit that have been exposed to is not a supplementary affidavit. A supplementary affidavit is an affidavit that makes notes of the content of the original affidavit and continues with the supplementary content that is contained in the supplementary affidavit. So the affidavit of the 6th of January 2025 is an original affidavit. I'm making that proposition to you. I can only change it if you come with an information that suggests otherwise. But the information that is at my disposal is an original affidavit, not a supplementary affidavit. It was signed by Mr. Barnard on the 6th of January 2025. By Mr. Adams, my apologies, Honorable Barnard. By Mr. Adams on the 6th of January 2025.
So on the 22nd of November 2024, we had a referral affidavit that refers the matter to IDEC and sets out in broad strokes the allegations. What I did understand from the investigating and prosecuting team, Honorable Nomvalo, is that they did a follow-up interview and statement taking with Mr. Adams on the 6th of January. So I've called it a supplementary affidavit because it was a follow-up affidavit. I'm not disputing what you have. They may not have written it as a supplementary affidavit.
So what was it supplementing?
So as we've gone through this process, also in MK15, what was being raised is what was in those dockets was not enough for one to decide. So for the further investigations to take place, a follow-up interview was held with Mr. Adams on all of the various matters to be able to get clarity and to be able to get more substance, which is what the investigating team sought to do.
Yeah, Advocate, I'm very worried that all what you are telling us now has not been mentioned in your statement. You have not told the committee that, or through your statement under oath, that there is an affidavit that was filed on the 6th beyond an affidavit that was filed in a referral application that you are referring to. So do you mean that the application, because the affidavit was signed after December, after the application was authorized for investigation? So you mean this affidavit, which was signed in January, was signed after the application was authorized? Then if that is the case, then why did you need to sign another affidavit on the 6th of January when an application already has been signed with an affidavit that you are referring to? Because if there was an affidavit, then it means the requirements were met, requirements for the application to be authorized.
The requirements were met, Honorable Nomvalo, for a preliminary investigation to be authorized. That is what was authorized. Once that is authorized, it means that the investigators can go ahead and conduct further investigations, which meant the taking of further statements and or an additional statement, whichever way you want to put it, from Adams, as well as then the obtaining of documents from wherever it is that they needed to obtain those documents. But without that, they would not have been able to do the follow-up that they did on the 6th of January.
Chair, I don't want to deprive people who want to, their hands which were up. I don't know if you'll note them.
Yeah, no, there is a standing principle that you run and finish your questions.
Okay, no, thank you very much, Chair. Now, you are saying the process was authorized, or the investigation was authorized on the 6th of December. Is that what you are saying?
Correct.
And then on the same day, you issued out a letter, or you wrote a letter to General Sentumula requesting for dockets. Is that what you are saying?
That is correct.
Now, do you have a letter in your possession?
I have.
I think Honorable Sangoni
Yes.
has also requested for it.
She
Did
has.
you
I
manage
asked-
to get hold of
I
it?
asked for the letter to be sent. It was sent to me on WhatsApp, which I have on my phone and which I can make available.
Okay.
Honorable Chair, I'm not sure if you heard me where I said, I do apologize if there are documents that any of the honorable members seek, if they could kindly provide a list so that in the course of next week, the documents that I am able to provide will be provided to the evidence leader for dissemination.
Yeah, my second problem, Advocate, with this letter, if I have a letter that is in your possession, unless I have a different one. On paragraph 1, it says, the letter is addressed to General Sentumule, and on paragraph 1, it says, the investigating director, Advocate Johnson, has authorized an investigation to be conducted in terms of Section 28 of the National Prosecuting Act. Now, You have said to this committee that the referral was made in terms of Section 27.
Yes.
Now, how does Section 28 come in?
So, in terms of the process, Honorable Nomvalo, the referral is a Section 27. When we have a referral, one considers the content of the referral. For an investigation to commence, the investigating director receives an application from the team, setting out the allegations, etc., and an investigation is authorized for institution in terms of Section 28. The Section 27 does not initiate the investigation. It initiates the referral and intake of a matter, which must then be adjudicated on, and then the investigating director must, if there's a decision that it must now be investigated, you must authorize an investigation.
Yeah, so what this paragraph says is that the investigation has been authorized in terms of Section 28. So do you mean that an investigation or a referral of Section 27 is authorized in terms of Section 28? Is that what you are saying in summary?
In summary, yes, and that refers also to, in the state capture matters, if I can just use an example out of the Zondo Commission or any of the other commissions, if we decide to look at one of those recommendations, even though there's a recommendation, a team must still put together an application that asks the investigating director to authorize the investigation into those allegations. So regardless of whether it's a Section 27 referral or how we source the investigation, investigations are instituted in terms of Section 28 of the NPA Act.
Investigations are instituted in terms of Section 28. So this investigation that we are talking about here, the investigation of a referral made by Honorable Adams, was instituted in terms of which section?
Section 28.
Not in terms of Section 27?
No, sir. In Section 27 is a referral. Once you get the referral, it's almost, when you get a docket, if there is no A1 complainant statement, you find that the detectives won't go and do anything with it. If it's just a report that was handed in, they still need someone to depose to an affidavit, a complainant statement. And so the referral is merely for the matter to be considered for investigation.
Okay, there are headlines which were circulating. I'm not sure if you saw them. In
I'm
December.
busy answering.
Oh, you're still answering? Okay,
Yes.
now you can
So
continue.
once that referral comes in, it is not automatic as well, Honorable Nomvalo, that an investigation will be instituted. I did indicate earlier there were certain matters where there was a Section 27. We found out it is being investigated elsewhere, it was referred there, or there were matters that didn't fall within the mandate of IDEC, and those matters were not taken. But we then engaged with the person who made the referral and pointed them in the direction of somewhere else in law enforcement that it can be. So we don't just say no, we also refer them there.
Okay.
Thank you, Chair.
So on the 6th of December, how many letters were sent requesting for dockets?
I would have written the letter to General Sentumule.
Yes.
I did ask my office to indicate that on the letters of Mr. Rapesu, Honorable Sangoni, whether or not I signed those letters. He's indicated, and they've sent me the copies, that I would have signed those letters as well. So those letters did go from my office. I could only, as I sat here, from what I recollect the letter that I sent myself to General Sentumule. And usually where there's matters of that import, they err on the side of caution and bring these letters to the head of office, and if I'm not there, to the head of investigations to sign.
Okay, so didn't you send another letter on the same date with the same content to the Deputy Provincial Commissioner of Gauteng, Major General Khumalo?
That is what I was explaining, Honorable Nomvalo, that initially when the questions were posed to me by the Honorable Sangoni, I could only recall the letter to Lieutenant General Sentumule the office has sent me the copies of the letters that were then, which means that when the communications were had with Rapeso and he was told to whom to address the letter, they would then have asked that the letter be addressed to the Deputy Provincial Commissioner, which is Major General Khumalo for Gauteng, and from the letter, he had brought the letter to my office for signature.
Okay. Are you done? Can we move to another one?
If you're satisfied with the answer, yes.
Yeah, no, I've heard the answer. There are remarks, in fact, let me not say it's remarks that you made, because it's headlines which were circulated in the media space. So the media might quote you out of context. In December 2024, they were quoting you to having said, when you were addressing your staff, I mean, I don't have to repeat them if you know them. Did you see that circulating? Those remarks that they were alleging that you have said during a staff meeting.
Please remind me, in the same way that I honestly
They were
slipped my
saying-
mind about that I signed a second letter.
Yes.
Please remind me.
They were saying that you were encouraging prosecutors to go to court with empty bags and files, even if those bags don't have files inside, and they must fake it until they make it.
And,
Do you remember that?
and you say that was when?
December 2024.
No.
You don't
What
remember?
I do recall is, and it wasn't a staff meeting, I remember that sometime in 2022, when one of the teams were getting ready to place accused on the court roll for one of the state capture matters, it was giving them a pep talk to be ready, to look ready, to be the part. It was at no stage, and I have provided context when I was asked, at no stage expect anyone to be bringing false cases, which was not what was said. It was a matter of, I said to them, mark the files, make sure that you look professional. Sometimes how you look, how you walk, how you talk is half the battle. It was about boosting their confidence. So I do not retract what I said. The context of what I said matters because much was read into how that conversation actually took place and who I was having that conversation with.
So the media, because the impression that they were selling is that you were encouraging prosecutors to go to court, even if they don't have files in themselves, just to go there and appear as though they are busy, even when they are not. That is an impression that was sold. So you were quoted out of context. That is not what you meant.
That is not what I meant, Honorable Member.
Okay. General Masemula, when he was here, he said that during the movement of dockets between SAPS and DPCI and SAPS to IDEC, some documents get missing. So they disappear. That's what he said. Is that true? Are you aware of that?
Sorry, Honorable Member, I did not hear that testimony.
He
If you
said
could
some
provide the
document,
context.
during the movement, some documents appear, I mean dockets, some dockets disappear. When they move from SAPS to IDEC, from IDEC to, when they move from SAPS to DPCI and from DPCI to IDEC, during that course, they disappear, some dockets. Are you aware of that?
I have no idea what the general was referring to.
You have no idea.
No.
When you have taken dockets from the police, what then becomes a role of a police officer who was in charge of a docket?
So in the context of IDEC, the dockets that are currently in our possession would have come to us firstly because many of those or some of those investigators were duty reassigned and are at IDEC. In fact, we still have 7 DPCI seconded investigators in IDEC. So they carry their dockets, they carry the IDEC matters, and any dockets we would have requested them because they would have related to allegations that were mainly made out of the State Capture Commission report.
No, the chair is saying I've run out of time.
I have not said anything.
Oh, I thought when you are, I
It's
thought
a-
when you are lifting it up like this,
it's a warning
you are,
to you.
you are indicating that my time is
It's a
over.
warning to you that your time is about to run out.
Okay, so do you then continue to give progress to those police officers who were initially in charge of those dockets, or they just discard them completely?
So if they are designated to the investigations, they are part of the investigation, and so forth. Therefore, they continue with the team. Where dockets are handed over to IDEC, what we do is we do go back onto the CAS system as and when the matters are finalized, which is part of the protocol, and we would then record guilty verdict or not guilty. Where there's a guilty verdict, we also have to indicate the sentence. Oftentimes, Honorable Nomvalo, we would end up keeping the matter till we have clarity that the accused may not appeal, especially where there's a conviction and where the state, where there's been an acquittal, has taken a decision not to appeal on questions of law. If there's no further action, dockets must be returned to the South African Police Services, and the return of that docket must be noted on their care system.
So for the time when they are with you, when they are with IDEC, how do you keep updated complainants? Do you keep them updated when they are in your position? Maybe when you are busy with investigation,
We should be engaging the complainants.
are you engaging them? Are you giving them progress to say, this is how far we are with your matter?
In terms of the investigations, it depends. A lot of the times the complainants themselves also engage with IDEC. If there is something to report, we do. But in the normal course of investigations, even if you are the DPCI, there's no back and forth between the eight.
Chair, do I still have time? We had an agreement with Honorable Skosana.
Sorry, Honorable
I
Chair,
had-
I was trying to finish my answer, and
Yeah, no,
the two
he's
members
putting
were
me
having
under
a
pressure. He
conversation.
wants me to donate some time
Yes.
to him.
He has 4 minutes
So I'm
left.
being generous.
He has 4 minutes left.
He can take it, Chair. I don't want to be unfair to him. It's fine.
Well, thank you, Chair. I just want to find out, Advocate. You know, this matter of arresting the team and General Khumalo for a HR matter leaves much to be desired. Let me ask you now, do you know that the National Commissioner has a moderating committee which looks at the process that is being undertaken by the junior panel? Are you aware of that?
Sorry, I didn't hear the last part.
The last one is that moderating committee looks at the process that undertake by the junior panel when it comes to employment. Are you aware of that?
No,
You are not aware of that?
no.
Now, I guess you know that only the National Commissioner who appoints, only the National Commissioner who appoints employees at SAPS. Are you aware of that?
As I indicated, Honorable Chair, in terms of process, it would depend, I guess, on the level of appointee. You would have HR that, and the CFO and the head of HR, which is also an acting deputy national commissioner who can sign certain appointments. But I have no doubt that the national commissioner can also sign, Honorable Chair, certain appointments. I just don't know which ones he's responsible for.
The arrested members that are accused of illegal appointing a person into a service, so why is the moderating committee and the National Commissioner not being arrested?
As I indicated, Honorable Member, there are no allegations that go to them. The allegations were restricted to these people that are at crime intelligence. But even then, the investigation has not shown that they had done anything wrong. If there is, of course, they have to be dealt with. but there isn't any evidence that they did anything wrong.
Was the National Commissioner engaged to confirm the allegations as given to them by the SAPS risk manager? If so, why not? If not, why not?
Sorry, Honorable Member, in
Let me
relation
repeat
to...
again. Was the National Commissioner engaged to confirm the allegation as given to them by SAPS risk manager? If not, why not?
I'm sorry, Honorable Chair, I'm lost. I'm not sure in terms of which matter. Are we still
No,
talking
we are
about...
talking about, we are still talking about the same matter, that there's a risk manager as well. What I'm asking is that, have you confirmed with the National Commissioner? Have you, or your investigators, have they engaged the National Commissioner in this matter?
I would hope that that is part of the investigation, but I don't have personal knowledge.
You
I
know,
cannot say if it was or wasn't done. I'm not in the investigation till there's the time for the matter for the ID and head of investigations to be briefed, Honorable Member.
let me close by saying the arrest of these crime intelligence members and Khumalo was malicious. They were detained overnight at Brooklyn Police Station, am I right?
On a point of correction, there was no malicious intent or arrest. At the time, and by the time, all the accused, there were 7 of them, were processed. It is a lengthy process. Court time had long passed, and so the first available time for them to appear in court on a first appearance was that morning.
They were not detained overnight.
What I said, Honorable Member, is they were there overnight because of, from the time we started processing all the accused, there were 7 accused to be processed. It takes time to process them. The courts finish at a particular time. So the first available time is for them to go to court the next day. So for those reasons, yes, they were kept in custody. It's a
Thank you so
practical
much.
issue.
The time of
Yeah.
the member has expired.
It's fine. I didn't get my answer because the time is over. But I just wanted to tell you that they were detained overnight.
Honorable Skwasa,
Thank you.
the time has expired. Can I check, honorable members, those who want to make follow-ups? Honorable Shongwe, Honorable James, Honorable Sangoni, Honorable Malema. 4 hands. The list is closed. Honorable Shongwe.
Thank you, Chair. Advocate. Kunenkinga la yazi, kunenkinga ngempela. Neven lami la ilanga phandle le lamabheseni elakudala uyalibona. Lilinde nje yabantu benkinga. Kunokugula okufanayo kuwo nobaba umchune engutholayo la. Okokuthi usho lokho bese ukuphika. Bese masukutholile ukushintsha ukuthi okay angishongo lokho bengisho lokho. Then when you discover ukuthi you said exactly this, you then say no, I said this but meaning this. One, you just said you didn't say that clip of a video. Now listen to this, let me read this to you. I asked that everybody go to court because you are a team, but we asked that everybody be dressed to the nines, and they were dressed to the nines. It happened.
I didn't say that I did not address the team.
I can play you the video.
No,
It's here.
I'm saying I did not say I did not address the team.
What
when
are you saying
the
about-
Honorable Nomvalo asked, I said, I do not dispute what was said. It is the context in which it was played or taken, the context, the meaning that was attached. I didn't mean that they must do something wrong. It really was me pep talking them.
But listen here, it says, I asked everybody to go to court because you are a team, but we asked that everybody be dressed to the nin, and they were dressed to the nin. You asked them to do this, and they did it.
So when we asked them to be dressed to the nines, it is important that people look the part. There's nothing worse than sloppy-looking investigators and
So
prosecutors.
we have you've asked them to do something and they did it.
I've asked them to dress to the nines,
Yes,
absolutely.
and they did it. You continue asking them in the same statement, in the same sentence, that they must bring files, bawabhale, even if there's nothing in the files. They must just take it to court, fake it until.
So, in that context, I'm not disputing the words. I'm saying the context was different because what was said before and the engagements before are not there.
Makodudlala ngathi.
Asidlali. Mntana kababa.
no,
Ngiyaphendula
no,
ngeqiniso
Honorable.
if-
Yebo, sir.
Honorable Shonga, if you ask the witness a question and in the process of her answering, you pass a remark, it becomes unpleasant. But my assumption is that you come from the progressive perspective. And in this perspective, men should be seen to be shading the patriarchal attitude. The fact that the witness appearing before you is a woman places an obligation on you to be seen respecting her and affirming her. But if it appears that we trample on her, it's not what we should be seen representing. That is the progressive perspective that you and I know very well. It's about affirmation of women. She may not give the answers that you want, but please.
Angixolise, Chair, but ke ngicabanga ukuthi mhlawumbe awuunderstandanga, Chair. Because what I'm trying to get to here is that she said these words exactly. And we did agree, mina naye ukuthi she did ask them to do exactly what she asked here. And they did exactly that, these people. But asidlule lapho, because we had agreed naye ukuthi just yengihlula ukuthi yana baba umchunu bayafana baphika into efanayo nje. The other thing that I want Chair to help me is that ngimushe parliament, Chair. Where do you get this law that makes you ungafuni disclose this affidavit to us? Where is the law? Umenga liphi? And Chair, through you, if possible, ukhona umthetho or awukho umthetho, can we get that affidavit? Because everything else she did say la, it needs to be part of the annexures. Last question, Chair, on follow-up is that the same thing that Ukhumalo is arrested for, breaking the law, eqashweni komuntu, is the same law she broke. Somewhere when indoda yakhe was being interviewed, the same thing, the similar thing happened kancane. We cannot shy away from that. Sesingayihlobisa ke sithi hayi bengazi in cha umthetho uphuliwe lapho. Even ngaphandle umuntu akavela hlonipha into ebalekile sixoxe nje straight ukuthi okay la kwenzeke leli phutha. So if we agree, ngicela ukuthi silithole le affidavit. Unless usinikeza umthetho ukuthi nawo umthetho, hayi ukuthi thina sivumelene ngokuthi. Uyangithola ngithi?
I do understand, Honorable Chair, if there is a regulation or provision that prohibits it, I will indicate to the evidence leader. If there's nothing that precludes it, I would have to consider that the document be made available.
Not satisfied. I just want to understand this. Did you come here leaving that affidavit behind on purpose, knowing very well that you stand on nothing that makes you go to ishiyele incwadi?
Not at all, Honorable
So why is she?
Chair and members. I did not see the necessity of bringing that document as it is part of an ongoing investigation. You've asked, Honorable Chair.
No, allow her to respond.
Okay, Chair.
You are now asking. I could blatantly say, absolutely not. I have said, I will consider whether there are legal provisions that prohibit the sharing of the document. If there is, I will make sure I communicate it. If there isn't a legal provision, I have to then consider that the document be shared.
The question is, uyishiyeleni?
Okay. Honorable James.
Thank you,
Chair,
Chair.
Chair, hayi Chair. Ngiyacela ngiyaxolisa ngiyakuhlonipha kakhulu lunga lami. You can't ukuthi ungivalele ngaphandle ngibuze question. Ukumprotector lokho Chair. Ngiyaxolisa kakhulu mphathi wami. But I just want to know ukuthi uyishiye ngasiphi isizathu? Uyishiyeleni? What was the reason eyenza ukuthi niyishiye? Because it's part and parcel of the, actually it's a most important document ekuvuleni kwaleli cala. So ngibuza ukuthi nje uyishiyeleni? Ngiyaxolisa Chair.
Honorable Chair, I cannot give a different
No,
answer than
I
what
did
I
not
gave.
say you must speak, Advocate
Thank you,
Johnson. May you please switch off your microphone. Honorable members, when you ask follow-up questions, I want to plead with you to understand that a follow-up question is a follow-up question. And we have said it many times here that we must not be opportunistic in the manner in which we ask questions. When you are given an opportunity to make a follow-up, ask the follow-up and let it end there. And let's not even debate the issues. And the time, Honorable Shongwe, that could reasonably be allocated for a follow-up has unfortunately expired. And I want you to support me in my decision that the meeting must proceed to Honorable James. I need your support.
I support you, Chair.
Thank you so much.
Thank you so much, Chair. Advocate Johnson, follow up with regards to the two letters. Would you agree with me that your testimony here today has been extremely inconsistent based on the fact that you said earlier on that you have a specific person in your department that writes letters to Gauteng. And later on, when you get probed on the same thing, it is found that you signed both letters on the same day with the same content, and then you say to us, oh, I remember, it slipped my mind. This has been all day, the entire day today, where you had to rectify what you said earlier on when a member comes in and asks either a follow-up question or asks a new question. It is really concerning. At this point, I didn't expect to find this. I didn't expect to find IDAC in this state that you have actually exposed today.
So, Honorable James, if I may, you are incorrect in your assertions that I sought to be untruthful. When questions were asked,
I didn't say that.
May I answer?
No, wait. Both of you wait. You know, the two of you are women. In public institutions. You are the head of IDEC. She is a member of parliament. These are the benefits of a democracy in South Africa for women. And when we walk out there, we are told how South African women do not support each other, especially black women. And when you come here, in parliamentary premises, in front of cameras, at this hour of the night, when everybody is back from work, you become so impatient with each other. You do not set a good example to young South African women. And regret this moment without telling anybody about your regrets. You can continue.
May I proceed, Chair? What I sought to do with the different questions was to clarify issues. I honestly, when we went through MK15, Honorable James, I honestly did not recall. I did not seek to bring the House under any misconception of what I did or didn't do. When the referral is made to Mr. Rapeso, I could only recall that I had written and signed the letter to Lieutenant General Sentumule. It is during a break that I asked the office, more so because Honorable Sangoni had asked for the date of the letter to Lieutenant General Sentumule. My office then sent, in addition, the letter that was written to Major General Khumalo. When I looked at it, it is as I looked at it at that time today that I saw I had, in fact, also signed the letter. That is how I was reminded. If I didn't see it and no one showed it to me, I honestly, Chair, would have maintained I had sent one letter to General Sentumule. I did not mean that to create any misconceptions about what I had done, because there's nothing to hide, Honorable James. If I did, in fact, write and sign, which I now see I have done, both those letters, there was nothing that needed to not be disclosed about those letters.
May I move, Honorable James? Okay, Honorable Sangweni.
Thanks. Thank you for the clarification, Advocate Johnson. So did you also sign the one to DNC crime detection?
Just want to remind myself, Honorable Sangoni, the two, I signed the letter to the Divisional Commissioner and to Major General Khumalo for Gauteng. Those are the two letters that were sent to me.
Okay.
As I have them, and I can show them to you on my phone.
No, that's
there
fine.
isn't a third letter that was sent
Okay.
to me. I can clarify if needs be, and I'm happy to revert through the evidence leader if that third letter to the DNC was in fact signed by myself.
Okay, please do, because it's got a bearing on what I was going to ask, because I was going to say, with that clarification now, do you still then stand by your evidence that you were not aware that these dockets were with the Division Inspectorate? And then, because I want to sneak in another question, I'm going to make this one question. You've gone to great pains to explain that IDEC was not behind the pursuit of General Khumalo in a nefarious manner. But would you find it acceptable if we were to make an assertion that perhaps the people who referred this matter to IDEC were behind this coordinated attack against General Khumalo?
I'm unable to comment because IDEC hasn't picked up anything to confirm that. And so what we did is what we got. And I still stand by, we were not told why the inspectorate had those dockets. And I did indicate, even Lieutenant General Sentumule, before I sent off the letter, I did call her to indicate I was sending a letter, as I've indicated I usually do. And she was also not aware, as she indicated to myself telephonically, that the document or dockets were with the inspectorate.
My last question, Chair, follow up as well. I got really worried on this issue of these media reports and people dressing to the nines, carrying empty boxes. Advocate Johnson, I asked if you were being interfered with from politicians. You said no. Would it be far-fetched for people to think that the IDEC is being used against people, especially politicians, if you are able to go to court with empty boxes, look like you have this thing happening, you're going to fake it until you make it? And I'm saying that not because I am not aware of the frustration that I think South Africans would have, the frustrations that you experience with corruption, but there's a growing trend, right? All politicians speak about state resources being used to fight political battles, and all of this is starting to look like it's part of the dysfunction within IDEC. So are you being used to fight political battles, or are you deciding to just charge people willy-nilly so that you fake it until you make it and hopefully you catch something one day?
Absolutely not. And if that was the case, there would be a hell of a lot more cases enrolled. There would be many high-profile people, politically exposed, political persons, persons in high office. We are currently criticized, Honorable Sangoni, for the lack of matters coming onto the court roll. And it is because we have to apply our minds to those matters. If there was an agenda, trust me, lots of cases can then go on the roll willy-nilly, and that does not happen.
Thank you, Chairperson. I'm done.
Honorable Malema.
Thank you, Chair. Advocate, is there any arrest of high-profile politicians and the cases that you said there's overwhelming evidence that is going to happen anytime soon by IDEC? Will we be seeing any arrest of high-profile people, especially those involved in PPEs and BOSASA and those kind of things anytime soon?
So, Honorable Malema, the PPE matters are all being dealt with by the DPCI and the Specialized Commercial Crime Unit. In terms of matters that we have in our space that arise from the commissions, yes, where there is evidence, there is going to be arrests, and there are some arrests that are in the pipeline.
Any former minister who might be arrested tomorrow or this week?
I cannot comment.
There's one coming. Now, if you had violated a law when you said in the panel that employed your husband, is it not within any reasonable South Africans to go and open a case if a law is violated and not come and want to grandstand and create an impression that they've got some big scoop which is non-existent?
You put it correctly and rather eloquently.
Secondly, as lawmakers and as citizens and as law enforcement, will it not help our institutions if we don't become fanatics and that those we like are allowed to be above the law and those we don't like, they can be subjected to any form of harassment because we don't like them? You have a duty to protect the Constitution. You have a duty to protect the law. It doesn't matter whether a person is a high profile. It doesn't matter whether a person occupies strategic position in crime intelligence or NPA or anything of that sort. The principle of no one is above the law applies to all of us, including our favorites. Am I correct?
Exactly, and everyone must be equal before the law.
Thank you.
Your hand is up, Honorable Nomvalo.
Chair.
Can I check with you?
Yes. Let me apologize, Chair. You know, I have so much respect for you.
You are the last person to ask questions.
Yes. I know.
So,
Chair, I just want to check.
you want to make a follow-up on your line of questioning?
Yes, a follow-up, Chair.
Wait,
The advocate has said...
wait, Honorable Nomval. May you please look at Honorable Sauls there next to you? You see him?
Yeah, I see him. I see him.
You remember he forfeited that exemption.
Yes.
So when you look at him and you look at yourself, you think it's justice that...
Point of order, Chair.
No.
That wasn't an exemption. I wasn't doing a follow-up.
Yes.
I wanted to.
That's exactly what I'm
I
saying.
wanted to give input, but out of respect to you,
Yes.
I just. But
That's-
it wasn't a follow-up.
That's what I'm saying, because when I noted you on the list of members who wanted to do follow-ups.
But mine is the follow-up.
And
His was not a
unfortunately,
follow-up.
I did not have a floor X-ray to predict that you were going to ask on a different matter. So I'm asking you, Honorable Member, do you want to make a follow-up on your own line of questioning?
With the greatest respect, Chair. Just one question.
Is it permissible?
For my records, Chair. Through your discretion, Chairperson.
Yeah. The discretion of the chair does not agree with that.
No, but Chair, just one question. You remember, you allowed him first to make a follow-up and you cautioned him. You said he must not do it again. And Chair, we agreed that the allocation of time must not compromise the quality of questions. I'm not just throwing a question because I enjoy the mic, Chair.
We allocated
I've got a
you-
particular interest.
We allocated to 30 minutes, Honorable Member.
So if you say I must leave here with no satisfaction, then it's fine, Chair. You are the Chair. You can use your discretion. That's okay. If you are saying I must leave here having not satisfied myself
The point
with
that-
one question, which is not going to compromise
Yes.
anything, Chair.
The
One
po-
question.
The point that I consistently make here is that these proceedings are not about the chairperson. It's about the respect that you accord to fellow honorable members who serve with you in this committee.
No, I didn't know, Chair, that asking for an opportunity to ask one question
Yeah.
amounts to disrespect. I'm hearing it for the first time today.
No,
but
no, look, if you feel that you are justified to ask, I can't stop you from asking. I'm going to allow you, and these fellow honorable members are the ones who will pass judgment on you. Thank you so much.
No, it's fine, Chair. Let's leave it. I will go to the advocate when we're done. Because we are refusing. It's fine. Let's leave it.
Thank you so much, honorable members. We have allocated your time to ask questions, and you used your time, and I want to thank you so much for that. Senior counsel, do you have any questions that you want to ask? Just before you ask questions, I have one or two things that I want to check with IDEC. Advocate, at IDEC, do you investigate?
That is correct, Chair.
And then after investigating, you can also charge
We can also prosecute, yes.
and then prosecute.
That is correct.
All these activities can happen in one institution.
That is correct, sir.
And then is there any legal or policy instrument you rely on to investigate, prosecute, and charge?
So we rely on the provisions of Section 28 and 29 of the NPA Act, but we are also bound in terms of the laws of evidence and constitutionality and admissible evidence by the Constitution, the Criminal Procedure Act, Honorable Chair, as well as the laws of evidence.
In terms of the South African constitutional architecture, is it not ideal to separate these functions?
Chair, where we are in terms of how the matters are being done currently, it has worked better to be able to investigate, have criminal and financial investigators allocated to those matters, as well as prosecute. Just to indicate, Honorable Chair, if you would allow me, even the then head of the DPCI, Lieutenant General Labia, actually had been engaging the NPA to say that when it comes to the other corruption matters that are being considered by the Specialized Commercial Crimes Unit together with the DPCI, he would have preferred dedicated, and he has said this, I'm sure, on other platforms, he wanted dedicated prosecutors, like what IDEC has, to be able to work in a similar methodology together with the DPCI, and to have that
I
capability.
hear what you are saying. I'm just going back to the question that Honorable Nhlanhla and Honorable Malema asked at the commencement of the proceedings about oversight. Let's look at fairness and accountability. Is it fair that you can investigate, you can charge and prosecute? The only thing that you do not do is imprisonment, or do you also do it?
No, and we also do not convict, nor do we acquit. We then follow the normal prosecution process of placing a matter on the roll before a presiding officer, and the rules of evidence and what we present are the same as everybody else. There's nothing different that we do when we
But
go to
do you agree with me that, or would you agree with an assertion that for us to enforce accountability, we may ideally need a separation of these functions.
In terms of how we currently function, Chair, I think it is a working methodology that works. We are able to do more because of that methodology, which is prosecution-led, and other agencies are asking for the same.
But is this not a negation of conventional practice in law where you do not find yourself being a referee and a player at the same time?
From where I am, Honorable Chair, I say that there are enough checks and balances in the legal process for any allegations that have to be dealt with, be they a malicious prosecution or an investigation. And even when we take the evidence to court, if a court feels that that methodology of IDAC, the evidence that it presented, does not fulfill the standard, then the courts would adjudicate accordingly. And I think just with the recent advent of the judge for IDAC, I think that extra measure also does come into play.
Okay. Maybe the second last would be, there is a constitutional court judgment against independent newspapers where the court ruled that the fact that a classified information would have leaked does not declassify that information. If I'm in possession of a classified information and I use it to open a case against other citizens, am I not offending the law?
It depends on who you are, how you came about, and whether or not you have a right. It can be an offense to be in possession of classified information without having the requisite authority.
Yeah, what I'm saying is that the information is not declassified. And there is also a judicial precedent that says, even if it might have leaked, even if you might have found yourself in possession, like when a person says, when I got to my house, I just found it underneath the door. Then I take it and open a case.
I hear what the chair is saying, and as I had indicated earlier, I do not know what documents, if one is referring to Mr. Adams, what documents he had, what the level of classification was. But on the principle, I cannot differ from yourself.
Okay. And then the last would be that, okay, let me say this. You have come here, you are not the first witness to come before. You are senior public servants or senior public officials leading different institutions. You have come here before us, before South Africans, and the things that you say, you contradict each other. You belong to the same cluster, the criminal justice cluster. And for sure, there are still others who will be coming before us who will continue to contradict each other the way you have been doing. Do you think this is good for the image of the public institutions that we seek to build?
No, Chair, it looks absolutely terrible that this is where we find ourselves, especially within the criminal justice system, because that is the biggest system, I think, other than social development that seeks to serve the public. It does not look good.
But is there an avenue within the criminal justice system to deal with these matters than to deal with them the way you have dealt with them?
I did say, Chair, that I hope that there would have been a different recourse. I do understand how this ad hoc committee or the Nhlanhla Commission came about. We do not know what all Lieutenant General Mkhwanazi had been exposed to, what he had been informed of, whether correctly or incorrectly. One would have preferred that this not have been the path chosen, but this is the path where we find ourselves. And we have to be able to help this committee and or the Nhlanhla Commission be able to come up with proposals based on the things we said together with ourselves to be able to make sure that the system works better and that we don't find ourselves here. I actually think that one should look at it. It is unfortunate but it should be a blessing in disguise. When we went on the FATF grey list, it was the same. It was a terrible thing for the country. But what it did do, Honorable Chair, is it forced us to look at ourselves, at our processes, at our measures, and it forced us to work together and look at where it got us. Sometimes you have to air these differences.
The person that we represent here as Parliament is the citizen. If the citizens were to express a sentiment that you are failing us as public servants, would you take responsibility for that?
I have to because I serve the people of the Republic. They are entitled to criticize.
If they were to say you are failing us, in your position, would you say, I take responsibility for?
I will take responsibility where I have failed, if they say I have, but I would also say to them, I've done the best I can with my circumstances, the time that I've been there, and that we should be given an opportunity to be able to continue with our work, the criticisms being taken on board, and to be able to do better. I can do no more than that.
We have not invited you here. We invited the head of the NPA, and upon reading our letter, she wrote back and said, IDEC says she wants to come to you. What is it that was so itching you that you wanted us to know as this ad hoc committee of Parliament?
Honorable Chair, I felt that some of the allegations that were being made were directed at IDEC, and I felt that as the ID, I would be best placed to deal with them, and that was the only reason I asked if I could come to the ad hoc committee. If there were no allegations made at IDEC, and very particular allegations, the National Director would have well been within her powers to be able to deal with all of those issues.
So you only came to deal with the allegations?
We came to deal with the allegations that were made about IDEC, about conspiring and or maliciously dealing with the Khumalo matter and or other matters, or seeking to disrupt the work of the PKTT. There were allegations made against IDEC.
Thank you so much, SC. No, Honorable Skosana, we no longer have time. Your hand is up. No.
In terms of time, Chair, we are not happy. You are not consistent and protecting the witness. Not necessarily that we are throwing stones to the witness, but it's not fair, Chair, that if a member is asking, and others are treated different from others, I think it's a cause for concern. But I wanted just to say, our legal team, those documents, those attachments, will have been in the report, in the statement. Now we don't have. We are living here. We assume that maybe they will send it one day. We're not sure. But thank you, Chair.
Honorable Skosan, the documents that you need, the head of IDEC has said that she will make those documents available. All of us here who are public representatives, and wherever we move or we go to across the country, we may be exposed to information which either the head of IDEC or the SC will not have. Like where I'm sitting now, I can produce a letter which maybe the head of IDEC has never seen it since she arrived in that, or she was appointed in that position. And I start to read the letter here. How would she have known that the letter should be part of the annexures? I think that is an unfair attack on the
Point
legal
of order,
team.
Chair, to you. Point of order to you, Chair, with respect, Chair. Point of
No,
order,
it's
Chair, to you.
unwarranted.
Point of order, Chair, to
Honorable
you.
members, let's let's make a list of the documents that we need. And there is a commitment on the part of the head of IDEC that those annexures will be made available.
Chair, point of order to you.
It's not a matter for debate. SC, may we proceed?
Thank you, Honourable Chair and honourable members. Advocate Johnson, when one of our most senior police officers in the senior management of SAPS says quite brazenly that he's got whatever you want to call it, an informer or moles or rogue elements in your office. The same officer who also alleges that, and that is what we investigating here, that the criminal justice system has been infiltrated, captured by certain elements, pointing fingers mainly at drug cartels. That's, if true, then it's more than a cause for concern.
That is correct. The converse is also true, that the Lieutenant General raises concerns of be it manipulation or interference, yet is unashamedly able to say, I have sources.
But what I want to ask specifically in relation to the allegation by General Mkhwanazi, who says that there are rogue elements in your office, why has that not been the subject of a complaint? It's either misconduct on his part, that he knows that there are people in your office who are leaking important, sensitive information relating to some or all investigations, or it is just plainly unlawful. Why has it just been left hanging in the air?
It was left not so that, not that it must not be dealt with. It was left so that this process, Honourable Chair, can proceed. I did indicate earlier that I will visit the issue once we are done with the ad hoc committee, so that it is important to engage General Mkhwanazi. He's the one who makes the allegation. It is important to know who those sources are and why it was necessary to have sources in IDEC.
It seems to me on a reading of the Act, Advocate Johnson, that there are two triggers for investigations by IDEC. The one is your Section 27, which is reserved for persons, us, individuals, members of the public, can walk into your offices, make certain allegations, and they may be asked to depose to an affidavit, and that person will say, in terms of 27, I've got reason to believe that a specified offence prescribed in the Act has been or is being committed. That is presumably what Adams did. And then the other route is the Section 28 route, which is reserved for the head of IDEC, for you, to, on your own, investigate a matter that may or may not constitute a specified offence. And the reason for that is, and we don't have to debate it now at this time of the evening, is because it arises from the Glenister case, which says that it's important for the head of the corruption unit, in this case, IDEC, to preserve its own operational independence and autonomy. Now, I can understand that you say it's only 27 because you don't want to be accused of being selective or biased and, in inverted commas, targeting certain people. But the whole point of 28 is that you as the head of IDEC, must be in a position to identify, for example, where there's state capture or whatever, not to wait for an individual to walk into your office to trigger an investigation.
So the investigations are triggered by 27, and in terms of Section 28, matter unspecified can be referred by the National Director to IDEC. And those kinds of investigations have been referred and they do get conducted.
But 28 also says that, 28(1)(a), if the investigating director has reason to suspect that a specified offence has been or is being committed, or an attempt has been or is being made to commit such an offence, he or she may conduct an investigation on the matter in question, whether or not it has been reported to him or her in terms of Section 27.
That is talking to the authorization of an investigation and the instituting of the investigation, not to the intake of a matter in terms of the 27 or the referral by the National Director. It means
But you don't have to wait for 27 in order to institute.
That
or to
28(1), Honourable Chair, deals with how an investigation then commences in IDEC. It means, as indicated in terms of the process, that where a document, an application is presented, Chair, IDEC, the ID applies his or her mind to whether or not there is a reasonable suspicion and therefore then activates an investigation. But it is based on the 27 referral and the 28 referral by the National Director.
Now, much has been, in fact, for most of the day, we were discussing, debating these allegations made by Honourable Member Adams, and we considered these investigations of the 6 cases. And I pointed out to you, and you accept that without your knowledge, that the police had also conducted their own investigation, and I read to you the conclusion, which I repeat: the affidavits in the dockets are basic, and in the opinions of this office lack elements of a crime. Now, it appears to be the case, Advocate, that if you look at the charge sheet, which is next to your affidavit, that the charges against Lieutenant General Khumalo and the 6 others are not in terms of any of these charges or these charge sheets that I've just referred you to, and which has been the focus of much of what we discussed today, and these dockets were sought, asked by you, and they were returned. In fact, if you look at AJ1, which is a copy of the charge sheet, you'll see that this relates to a charge that was laid at the Brooklyn police station, and that the date of that charge was in 2025. So this affidavit that was deposed to by Adams on the 6th of January relates to this charge, the Brooklyn charge, and none of the other 6 charge sheets.
So for purposes of clarity, Honourable Chair and members, and apologies, I just have a slight irritation in my throat. We conduct the investigation, and when we seek to place persons on the court roll, we have to register a docket for that matter. Hence, you have a Brooklyn case that is registered because they are being arrested on a very specific matter. We register a docket for that matter to be processed. What happens with the dockets that we did receive from the police, they form part of our investigation and part of our evidence. But as we enroll, we register dockets for the enrollment of those matters. And that happens across the board in all the matters that we deal with, Chair.
But is there any reference in the charge sheet, the consolidated charge sheet, which is a fairly bulky document, that it is purely for purposes of securing firstly the arrest, because the arrest is made in terms not of any of these 6 dockets. They are made in terms of the Brooklyn case number. The appearance in court, when the prosecutor reads the charge, is in relation to the Brooklyn charge sheet, not any of the other charges. Unless you can point out in the consolidated charge sheet that there's reference to any of these 6 dockets.
It's not referenced in the charge sheet. When evidence is led, Honourable Chair, evidence will be led on how those matters, or this matter came to IDEC, what the investigation dealt with, that is what the investigating officers would have to deal with and testify to, and if questions are raised, they would be able to explain that once that investigation was concluded, the matter was placed on the roll in terms of a Brooklyn case, which is then the IDEC matter that is placed on the court roll.
So
No
the
reference is made in the charge sheet to the previous docket, but it will be made in terms of the evidence that will be led.
But we've, perhaps it's not a good time of the day to unravel these things. But we heard today that the matter was brought to IDEC in early November. From the affidavit made by Honourable Adams, there appeared to be some reasonable belief that it warrants further investigation, came to you on the 16th of November. You then authorized the further investigation of the matter, and then subsequently, in December, the prosecution was authorized.
The investigation
So
was authorized.
yes, the investigation. So the charge, in fact, was only laid at Brooklyn in early January.
No, if you look at the charge sheet,
So, yeah, the date of the appearance was 27 June, and the investigating officer is Senior Investigating Officer Padiachi.
yes, and the case, sorry, Honourable Chair, the case docket itself was registered in June of 2025 to place the accused on the roll. Because when you look on the charge sheet on the first page of AJ1, the CAS number is 542/6 of 2025, and that talks to the month in which the docket is registered for the accused to be placed on the roll, which was also then that month of June.
So, but there's no indication, and that's what I'm asking. I can't make wild assertions at this time of the day, but there's no indication that this case or case number is a consolidation, actually, of the 6 other dockets, the 6 other complaints. Because as I understand it, it's only 6 dockets because quite literally, Honourable Adams appears to have been given the runaround. He registers cases in Cape Town, he has to register a case in Gauteng, he doesn't get any joy, doesn't get any feedback, and then he ends up complaining to the minister. And the minister's chief of staff writes to you and say, there are these complaints. And then the next thing, Honourable Adams is referred to IDEC, and that is when the investigation starts.
Correct.
But there's no indication in this charge sheet in relation to what is the background, if that is indeed the case, that this Brooklyn charge is a consolidation of these other complaints or charges relating to Honorable Adams?
Honourable Chair, I hear what Council is putting to me. What I'm saying is that that will be led in evidence. We do not make those averments in the charge sheet. When one leads the evidence, one will talk about the genesis of the investigation, why the matter was at IDEC, what it is that IDEC investigated. That is part of what the investigator will do. Reference isn't made to those CARES numbers within the charge sheet. In the manner in which charge sheets are ordinarily done, that is not something that we do.
But with respect, Advocate Johnson, that doesn't relate to the evidence at all. In fact, that's what we're trying to do here today, is to pierce all this together. What I've read to you, which you said you weren't even aware of, that the police were investigating these 6 dockets. So we know the docket numbers, we know what was in the docket, and we also know that very senior police and a legal opinion said there's no basis for us to proceed with any prosecution.
I understand the point. I'm merely indicating that IDEC then declared an investigation. We conducted investigations, and when we were ready to enroll a matter, we enrolled the matter on a CARES number for the new investigation that is IDEC. Evidence will be led about how those matters came to IDEC, Chair. I can't take it further than that. That is the process that is followed.
And then just lastly, in relation to these charges, it is then also brought in terms of section 24(2). And if I can just read it back to you, it says, in addition, sorry, it relates to the powers, duties, and functions of directors and deputy directors. And then 2 says, in addition to the powers, duties, and functions conferred or imposed on or assigned to an investigating director, such an investigating director or any person authorized thereto by him or her in writing may, for the purposes of criminal prosecution, A, institute an action in any court in the Republic, and B, prosecute an appeal in any court. So, does this also mean that in addition, the prosecution had to be authorized by the DPP for Gauteng?
So what happens, what 24(2) says is that the investigating director, after consulting with the Director of Public Prosecutions, will then enroll the matter. The consultation is to inform the Director of Public Prosecutions of the matter. Hence, we send a prosecution memo setting out what it is we allege and why we want to enroll in that jurisdiction. We don't seek permission for the prosecution to proceed. We seek permission for the matter to in that jurisdiction.
I think, to be fair, that's what you said earlier this morning.
That is so.
When I asked you what the steps were. But you didn't mention section 24(2) specifically.
That is the section.
Thank you very much from our side, Advocate Johnson, for all the time. You must be tired, and your cooperation with us, the evidence leaders, and your appearance. Thank you very much, Chair, honorable members.
Thank you so much, SC. Thank you so much, Advocate Johnson.
Thank you,
Honorable members, next week, on Monday, we are having a committee meeting with the ad hoc committee. So we will check with yourselves what are your traveling arrangements so that the meeting should accommodate that. Ideally, we can start meeting at 11 o'clock so that you are able to fly back to Cape Town in the afternoon. When you say which other committee do you belong to, because you belong here, the ad hoc committee. Yeah, that's what virtual. Because when you say what I hear, where I'm sitting, I hear which one. Yes, so Tuesday, Advocate Badoi will be here. And then Wednesday is the medium-term budget policy statement. Parliament expects you to attend, all of you. And then we have Mr. Cedric Nkabinde on Thursday. Thursday or Friday? On Thursday and Friday next week. Yeah, so you have the program for next week. Let's meet on Monday and finalize everything for the other coming weeks. But for next week, you know your work is cut. You know the activities which are coming. Advocate, we want to thank you so much for creating time to be with us here, but also volunteering to come and join us here and contribute on how you think we can fix the problems that we have as a country. Thank you so much. Honorable members, we have come to the end of the proceedings. Thank you so much.